Hi, everyone. Thanks so much for joining us. If you don't know me, I'm Gideon Newmark. I am the Appellate Program Manager for the Washington State Office of Public Defense, coming to you from beautiful Olympia, which is not currently choked with smoke in my virtual version of it. So this event on appellate brief writing, I can't take very much credit for this event. It was brought to us by the judges Glasgow and Cruser through Rania of NK, which she was our go-between, for which I'm very appreciative. And they had this event prepared, which they'd given to another group, and they were kind enough to offer to put it on for OPD. And of course, who wouldn't jump at the chance to get free CLEs from judges on appellate writing, because they're the ones who see it every day, and they see what works and what doesn't. And of course, they have their pet peeves, which we all want to avoid. So that's about all I'm going to say, other than you should, please check the chat for the link to the evaluation form. Also, my email is there if you have any follow-up questions. There may be, you can ask questions during the event through the chat, or after the event, you can email me and I'll pass them on to the judges for you. I also have the reporting form posted in the chat. The CLE and the CLE credits are going to be due on Friday. If you want OPD to report the credits for you, this does not apply to you if you are watching the recording online, but there will be details posted in the YouTube channel. There will be the reporting number posted in the YouTube channel for you to be able to report the event for credits if you're watching it, watching the recording. So without any further ado, I will turn it over to Judges Glasgow and Cruser. Take it away.
Well, thank you very much, Gideon, and thank you everyone and Rania for inviting us today. We've been really excited to do this presentation for you. I wanted to tell you a little bit about my background, and then I'll have Judge Cruser introduce herself, and then we'll cover a couple of little housekeeping issues, and then we'll get started. So as Gideon said, my name is Rebecca Glasgow, and I ran for the Court of Appeals from my district in Division 2 in 2018 and joined the court in January 2019. So I'm a relatively new appellate judge. I was not a Superior Court judge before I joined the bench. So I came straight from an appellate practice that was primarily civil. So part of my role in the CLE is to talk to you from the perspective of an amateur when it comes to criminal issues. And I think that's, we think that that's valuable because it's not at all uncommon for judges on the appellate bench to come to the bench with only civil experience and very little criminal experience. So Judge Cruser.
Hi, I'm Judge Cruser. I joined the Court of Appeals in March of 2019. Just shortly after Judge Glasgow did. Prior to that, I was on the Cowlitz County Superior Court for about 18 months. Prior to that, I was the head of the Appellate Department in Clark County Prosecutor's Office. And prior to that, I was an OPD contractor. I did that for about 7 or 8 years, and started my career actually in prosecution and then went to OPD and then back to prosecution. So as Judge Glasgow mentioned, we have a mix. Well, right now it's maybe not the best mix, but we have usually a mix of judges who have civil experience and criminal experience. Right now it's maybe tilted a little bit more on the civil side than the criminal side. But sitting in panels of 3 makes that much better because then we can all discuss the cases and feed off of each other's knowledge and experience in each area. So Judge Glasgow, obviously having come from the Solicitor General's office, she is very well versed in brief writing and persuasion, oral argument, things of that nature. And so we'll do our best to sort of tag team your questions from both of those perspectives.
Yeah. So a couple of quick housekeeping things. First, Gideon mentioned that you can submit questions in the chat box, and he will interrupt us with your questions, and we're happy to be interrupted. It's really most valuable to you if you're asking questions as we go, so please don't be shy about that. And we will also ask you at the end to think about questions that we might be able to answer for you next week about appellate procedure in particular. So if there are procedural questions that you've always wanted to know the answer to, we will tell you how you can submit those. So definitely start thinking about that. In addition, of course, we would have loved to have been with you in person. Zoom makes the presentation a little bit challenging. We're both dealing with multiple monitors, so please forgive us if we're sort of looking around. I know I'm going to be looking up quite a bit. And we both have children who are in school right now and using the video. So if one of us has to pop off of our video feed and just go to a picture, that's because our internet is a little bit unstable. So we appreciate your forgiveness in light of the way that we have to do things these days. So we will go ahead and get started. Our goal here is to do a deep dive into persuasive brief writing, but know that we understand that your time is incredibly limited. And so our goal is to try to give you the biggest bang for your buck. So give you suggestions that you can implement and with a lot of efficiency and in very little time. But know that we understand completely that you're all very busy and that you're on tight deadlines, both for preparing briefs to submit to the court and for oral argument. So Judge Cruser.
Oh, this is my slide. So this, to a degree, this applies mainly to trial counsel, I guess. I always had a difficulty when I was doing appellate defense. The record is set by the time it arrives on your desk, and there's a lot that you are stuck with that you would wish had not been formed in the way it was formed. So what I would say about this is that it's important to designate every item that you would like us to see, and to, because people will forget to, they won't designate the clerk's paper that then you realize at the last minute you need to have designated, or an exhibit. So make sure that we have the complete record that we would need to see in order to evaluate the assignments of error that you're making. And if you need to really look at the RAPs and see if there's some way that you can supplement the record if you think it's necessary. It can be difficult to do that, but there are ways to do that. So I would encourage you to think, really broadly about what you need to get before us so that we can really evaluate your claims. And sometimes you might consider filing a PRP at the same time as a direct appeal if you're trying to, or if you think that we need to evaluate something that wasn't properly made part of the appellate record or can't be made part of the appellate record, the direct appeal record. You could consider filing a PRP. I understand that that's not part of what the appointment is for, your appointment with the client, but that's something you might consider. But to a large degree, this does start at the trial court level. And I know that there's some amount of communication between the appellate bar and the trial bar that maybe, make sure that they understand the importance of making a proper record, whether it be the basis for an objection, the basis for objecting to a particular jury instruction, things of this nature are really important to have in your record. So that's what I would encourage you to think about doing.
So of course, the first step is always the notice of appeal. And to the extent that you have control over this document, or you have the ability to advise the people that have control over this document, of course, the first thing you need to know is what is your deadline? I mean, this is almost the one place in appeals where missing the deadline is almost always fatal. it's very hard to overcome a missed notice of appeal deadline. We actually added this slide recently because in some cases we are seeing the issues that are raised by the second two bullets a little bit more often than I was expecting. This was one of the things that was surprising to me has been surprising to me over the last year and a half that I've been an appellate judge. It's surprising to me how often someone misses actually appealing the order that they want to appeal. And so doing a quick double check to make sure that, one, you've listed each order that you want appealed, and that you attach them to the notice of appeal so that you don't have to rely on the RAPs to incorporate orders later. There are ways to do that, but the best possible situation is that you've listed each order in your notice of appeal and attached each order. The other thing that I have also seen recently that surprised me was that if you add descriptors or limitations in the language of your notice of appeal, the court is going to pay attention to that. And so be cautious about any limiting language that you actually include in your notice of appeal. That's that's a way that people can stumble, I think, probably unexpectedly into problems. Judge Cruser, did you have anything you wanted to add about that?
Well, I would concur with what you said about please attach the order that you're taking appeal from to the notice of appeal. And please remember, the RAPs do require that the notice of appeal be designated as a clerk's paper. And so I've been seeing that quite a bit where the notice of appeal is not designated as a clerk's paper. And it does create problems just being able to even cite to it or how we deal with it on our end. So it's much better if you remember to designate the notice of appeal as a clerk's paper. But I would agree with, and also with the notice of appeal, I don't recommend restricting yourself unless you feel that there's a compelling reason to do so. So also please pay attention to what it is you're putting in the notice with respect to what you want us to review. I would also say, I think we all can agree that in the criminal realm, it's much more likely that you'll be able to pursue an appeal when the deadline is passed, obviously than in the civil realm, because in the criminal realm, what you will often find is that there has not been a proper waiver below or that there hasn't been a proper advisement, I should say, of the right to appeal and the timelines for doing so. So it's much more likely in the criminal realm that you will be able to cure that defect than in the civil realm. That's not me encouraging people to be late with their appeals. I'm just noting the fact that there should be no hesitation to file a motion to file a late notice of appeal because these are criminal cases and we need to hear these appeals.
Thank you. That's a very good point. So this one's yours.
Oh, all right. So this is interesting debate that back when I was an OPD contractor, there was some debate amongst colleagues about making assignments of error and whether you should winnow them down to the best issues that are more likely to compel the court to rule in your favor, or whether storming the barn and just having 50 assignments of error on every single thing. And people would come down differently on that question. I can tell you that it can be very, I think a more persuasive brief is one that's focusing on some more limited assignments of error that you can then make a compelling case, because the more assignments you have in there, the more difficulty you're going to have getting it all in under your page limit. And so you really just need to think. Also, I would say, think about what issues maybe are more properly raised in a personal restraint petition rather than the direct appeal. So I would encourage you to be strategic about that. But I think from my point of view, I would be selective about your assignments of error as opposed to extremely broad with them. while still preserving the things that you need to preserve for the client. Judge Glasgow, do you have anything you wanted to add?
No, I agree with you on that.
Yeah. Let's see. All right, so with the assignments of error and associated issues, I will say that not to take anything away from a lot of the civil practitioners we get, but typically the criminal appellate attorneys, particularly those working with OPD, are very good at making it clear what the assignment of error is, and we appreciate that. The separate and concise statement of each error, and the thing that we do tend to see is making an assignment of error about, well, I want to assign error to 10 different findings of fact and putting them all in the same assignment of error. It's much easier for the reader. And remember that our clerks are reading these briefs before we are, to separate out a different assignment of error for each finding of fact and conclusion of law, and also a separate distinct assignment of error for each instruction. Also, it's important to restate the finding of fact that you've assigned error to. So rather than have the reader, whether it's the judge or the clerk, having to go to the clerk's papers and do a side-by-side of to look at the assignment of error and what it said, or the finding of fact, what it says while we're reading the brief. It's much better to when you're talking about the finding or conclusion you're challenging, to have rewritten it, printed it in your brief so that I can look at it while I'm reading about what you're saying. And the same thing goes for the instruction. And I think there's a wrap on this that you're supposed to put the instruction and possibly the finding of fact. I think Judge Glasgow is going to look at that maybe and have better information in the brief. And we see it all the time that it's not there. That, well, I'm challenging this instruction because it relieves the state of its burden of proof for this or that reason, but the instruction is not actually in the brief. And so that is less helpful. If you attach it as an appendix, that can be more helpful, but it's much more helpful if it's actually in the brief, so that I can look at the wording of the instruction then I'm going to jump down and look at your argument about it. And the same thing goes with the findings and conclusions. So I'd really strongly encourage you to do that. It's very important. Judge Glasgow, did you have anything to add?
No, but I think
I have
a question. Yeah.
I have not a question, but a comment, which is that in terms of mashing all this assignments of error into a single one, is probably a practice that developed because of the page limit. But because of the new rules changing our page limits to word limits, there's actually not a good reason to compile all of your kind of assignments of error to findings of fact into a single assignment of error. It's now actually, there's no disadvantage and a lot of advantage to separating them out one at a time. It might end up being really long, but your law clerks and your judges will appreciate the ease of tracking whether you've assigned error to something or not, because that is something that the courts pay attention to. That's something that especially, law clerks are kind of, and judges are detail-oriented people who don't appreciate it when you make their life hard in terms of verifying that each challenge finding has had error assigned to it.
Okay.
So one thing that that we have covered in this before, and this may be a quick discussion for you guys who are mostly, if not all, appellate attorneys. But one thing that we often see is an inability to shift from the trial perspective to the appellate perspective. And that really hamstrings people's ability to be persuasive in their brief. And so we encourage people to consider any new barriers that may come up on appeal that weren't barriers below, sort of the most obvious, or one of the most obvious ones, is, you know, remembering that the appellate court isn't going to revisit issues of credibility. So arguing to us about whether or not a particular witness was credible isn't going to be that helpful to you. So sometimes we see people who are doing both the trial level work and the appellate work sort of continue with those types of trial level arguments that don't get traction in the Court of Appeals. So just having that sort of understanding of what the barriers, the new barriers are on appeal, and remembering them. Of course, always remembering the standard of review is the lens through which we look at everything. And our new law clerks are baby lawyers, but they get drilled into them very early that the standard of review is something they have to address in every pre-hearing memo that they give us. And they have to apply the standard of review as they're applying the law to the facts in every pre-hearing memo that they give us. So knowing that that's drilled into them, and it's something that we're constantly discussing in conference, there shouldn't be a situation where you're not addressing the standard of review in your briefing and or in your oral argument. Even aside from the formal standard of review, it's important to recognize that judges are human beings. And so a lot of times we have particular inclinations or biases that you might have to overcome or get us to sort of recognize and overcome. And one of those things, I think, is just a general deference to trial judges. When you become a judge, you have to step away from your life as an advocate, and you have to step away from all of your sort of relationships with attorneys who are advocates. And you join this club of judges. We get together in normal times. We get together for conferences a couple of times a year. We spend a lot of time together, in part because we can't spend a ton of time hanging out with our friends who are lawyers. And so that means that judges sometimes will have a little bit of an attitude that we are we're a group, and we give deference to each other just because it's human nature to sort of align with the people who you identify with. And so understanding that sometimes that, I think, implicit bias towards a general bias towards trial judges exists, and understanding that in convincing us to reverse a trial judge, that's something that you have to overcome a little bit. And I think that everyone that I know on the appellate bench in Washington is good at taking that implicit bias and putting it aside. But nevertheless, I think it's important for you guys in particular, because you so often are the appellant, to just recognize that that's a thing, it exists. And it's something that we'll talk about in a couple of slides. We'll talk about strategies for dealing with that. But I think it's first a good thing to sort of acknowledge. So Gideon, did you have a question?
Yes, we had a question in the chat asking with regard to not talking about witness credibility on appeal, what about when discussing a harmless error prejudice analysis? I think the angle of that question is, if you have an error which can be harmless, is it valid to argue, well, this error wasn't harmless because XYZ witness was not credible for XYZ reason?
So that's a really good question. I feel like, and I think Judge Cruser will probably do a better job answering this question than I will, except that I'll just say that generally, I feel like people tend, when I worry about feeling like an attorney didn't do something with harmless error. I'm more concerned when they didn't make a harmless error argument at all, or they didn't explain how the error was harmful at all. They just forget about it or don't do it. or I don't think they take their best shot at it. And so I do think that when we're evaluating the strength of the evidence below, that is a place where you should probably be making your best arguments. I don't remember a time, though, where we've thought that if there's been a fact finder that's made a credibility determination, that we've been willing to directly say that that credibility determination was wrong. That's just not our territory. But Judge Cruser, do you have more to say about that?
Well, I'm trying to think of some instances where it might even be in a sufficiency context where you're evaluating the case, and when you separate all the wheat from the chaff, you see that the state's case rests on a witness who maybe is equivocal. Maybe you're not asking us to find somebody explicitly not credible, because we're not allowed to disagree with a jury's determination about credibility explicitly, but from time to time it might be a situation where a witness was just didn't give enough information or was equivocal in what they said, where you're asking us to look at whether it be a sufficiency or harmless error context about whether the error was harmless, given that the state's case rests maybe largely, maybe exclusively on a witness who even if this witness was truthful, it still wasn't going to be enough to get the state over the line where they need to be to have the case affirmed. So I can see how you can dance around the edges with that. And I would also agree with Judge Glasgow that it's always good to take your shot. You are writing the brief for the court, but you're also writing the brief for the client. The client wants certain things to be argued, and pretty much almost everything is going to be in bounds in a criminal appeal. We have, certain rules about, making frivolous arguments, things of that nature. The civil world is different, but within the criminal appeal context, very few things are going to be just outright out of bounds, because you have a duty to make your arguments that you feel are appropriate. And so I would absolutely encourage you to make the argument that you feel you need to make. Whether we end up being able to do to reverse on that basis is a different question, but I think that's within bounds. All right, Judge Glasgow, there you go.
Thank you. I'm sorry, I was having a little bit of a connectivity problem there, so I apologize.
All right. Oh,
sorry.
Yes.
Oh, I'm sorry. The last two things on the list are in shifting your perspective to appeal. And I think probably you guys are always thinking about this, but don't forget that our view has to be about almost all the time has to be about whether or not what we say in this case is going to impact future cases. And now that we have GR 14.1, we have to think about that in every single case, even if it's unpublished. So the magic date for GR 14.1, which is the rule that says that you can rely on unpublished cases for persuasive authority, is March 1st, 2013. So any unpublished case after that date, you can rely on for persuasive authority, but you have to tell us it's unpublished. That's the impact on you. The impact on us is that everything we say, even in an unpublished case, can later come up as part of an argument in a later case. So don't forget that we're not boxed into your facts. We need to think about how what we're going to say is going to impact future cases. And so that is actually a lot of what we spend time talking about at conference.
I would add to that a little bit. I'm a fan of this rule, and I would encourage you to liberally let us know when either there's another case in our division or the other divisions that have come out with a case, an unpublished case that touches upon the claims you're making. We sit on a lot of panels each year. We either are writing or sitting on a panel signing off on well over 200 cases a year. We're human. And so sometimes maybe we won't recall that Division 1 touched on this very issue, a year ago. And it's very helpful for you to list or let us know about unpublished cases that you feel have persuasive effect on the case before us. So I would encourage you to use that liberally. All right, developing a checklist. You know, obviously we're dealing with some high-level practitioners here. This, you know what the deal is on this, but it's important, at least from my perspective, don't try to breeze by an unpreserved error on the hopes we're not going to notice. Sometimes a panel won't notice, but oftentimes the panel will. So it's much better to, you know, to acknowledge up front that this is an unpreserved error and that you're asking for it to be reviewed under 2.5 and to go through the analysis rather than jumping right in on the merits and then having us have to go through the analysis. So I would encourage you to do that. I've just been seeing a lot of briefs where it's just, there's just a jumping right in without going through 2.5. So it's, please don't do that. And then of course, are there findings of fact that need to be challenged? We see from time to time that somebody is making an argument related to a finding of fact that they seem to be challenging in their argument, but they didn't assign error to it. So please, you know, make sure that you remember to assign error to every finding of fact that you need to. And we'll see these, you know, giant findings of fact sometime from the trial court. So if there's a portion of the finding of fact that you are not challenging and you want us to focus on one aspect of a finding of fact, please let us know. Rather than just, you know, assigning error to the entire finding of fact, and then we have to sort of guess at what's going on there. So because sometimes the findings of fact just aren't done properly below. So was any alleged error potentially harmless? Yes, it's of course always important to go through that. Obviously from the state's perspective, they're the ones who are trying to persuade the court about harmlessness, but from your perspective, you know, if the error was not harmless, please tell us why. And I think maybe there's another slide later that's going to get to this, but if there's a disagreement about what the standard of review is, or if there's a disagreement about whether the error is constitutional or non-constitutional, I think it's, you know, better to say the error is not harmless under either standard. Just go ahead and argue why you win under either standard. And then of course, is there a time bar you need to overcome? You know, typically that's going to be more in the personal restraint context or the 7.8 that's been transferred to us. But, you know, sometimes you'll have a judgment and sentence has been corrected in some way, and maybe you want to challenge something that was in the original judgment and sentence. You got to make sure that, you know, is there a barrier to that? You'll want to look at that. So I think that's about all. Anything you want to add to that, Judge Glasgow?
No, except that I'm a huge fan of checklists. And so I know as a relative, as someone who didn't do a ton of criminal work before I joined the bench, I have, one, really loved working with Judge Cruser, of course, but two, for myself, as I've conferenced cases with her and had her bring up some of these sort of initial barriers, procedural barriers that maybe both parties have missed, I've developed in my chambers sort of a procedural barriers checklist for criminal cases. I kept a similar list when I was an appellate practitioner on the civil side. And so I would work down the list to make sure that there's nothing that I'm missing. Now, I did mostly defense work on the civil side. I was most often the respondent on an appeal. And so I would use the checklist to make sure that I wasn't missing any arguments about throwing up barriers to my opponent's appeal. You guys aren't usually doing that. You're usually on the other side, but knowing what those barriers are is really helpful. And so I'm working on developing a checklist, actually using Judge Cruser's brain as my source. And so if I'm doing that, then it's really helpful for you to have something similar so you know what the judges are thinking about. I think I need a checklist because I am less steeped in the criminal world than Judge Cruser is. Her brain just naturally does it, but all of us are looking for these things all of the time. And so a checklist can really help if you're super busy and you just need something to tick down to make sure that you've thought of everything or you've addressed everything. Okay. So the next step in appellate brief writing should be taking a moment to step back and think about some overarching themes for your case. And this doesn't have to take a long time, but it is really helpful to us if you take a moment to think about the case from our perspective. So put yourself in the shoes of the appellate judge who's going to have to write the opinion in your case, and try to think through what it is that we need to know in order to decide the case in your favor. And we'll talk a little bit more about this on a later slide, but one of the important things that you can do early on is imagining your ideal opinion. What would be the ideal structure? What would be the ideal analysis? And what information do we need to get there from you? And then it's also important to think again about the fact that judges are human beings. We're not automatons. And so one of the things that Chief Justice Stevens frequently says when she's doing CLEs on appellate practice is that it's important to stop and think about what would make the judges inclined to rule in either party's favor from a human perspective. So she says, think about what it is that would give the judge passion about ruling in your client's favor. What would motivate them from sort of that central goal of achieving justice? And then give them permission to get there by showing them the structure of the analysis that gets them to the result that you want. But it's important to develop both that passion and permission. And if you leave out one or the other, then you're missing an opportunity. Judge Cruser, did you have anything more about that slide?
No, I guess I would just say that this is, tell a good story. There's a lot of, there can be more to work with in some cases than others, but to the degree that you can, please tell a good story. And in a case that you really need to bring the heat, bring the heat. Cases where you will have a lot to work with, maybe the state relied on witnesses that are quite unsavory or things of that nature, make sure to, give the whole picture in a way, because also we understand that you're writing not just for the court, but also for the client. And so make sure to feel that freedom to really tell your story, tell your client's story in a way that makes it compelling and makes the judge think that, ruling in the favor of your client is the way that justice will be done. So, that's, I think, the passion part that Judge Glasgow was talking about. And so, and everybody likes to read a good story. And I like an introduction. I don't know if we're going to get to this in the later slide, but, the introduction section of the brief where you give the snapshot of what we're going to be seeing in this brief, what the case is about. You can throw in part of the story there, and it really sort of gets to read, oh, this is going to be good. This is going to be a good story. And then you get to the facts, and it's even more of the great story you're about to read. So, feel free to do that. And if you feel the need to bring a lot of passion to your story, you should do that. Okay. All right. So, whoops, did we skip one? There we are. Okay.
There we go.
These are sort of the nuts and bolts. If you're, whatever claim it is you're making, we need to have the framework for the claim. I am bringing a double jeopardy claim. Here's the test. I'm bringing whatever claim. Here's the test. Here's the standard review. Here's who has the burden of proof. Things like that. So you will see from time to time where if the parties are disagreeing about either what the test is, what the standard review is, Certainly you want to come back in a reply brief and say, you know, well, the state got it completely wrong in their brief and here's why. And so these are the things that are the tools we need to get to where you want us to be. How, and this is sort of going back to the last slide, the permission part that Judge Glasgow was talking about. You know, to get from point A to point E, we have to get through all of the things that we need to get through to get there. So we need to understand, you know, who has what role to play, of course, with respect to the burden of proof, the level of proof required, things of this nature. You know, we need to know what the test is. And Judge Glasgow, did you want to, and then also just talk about, are there limitations on review, talking about the credibility determinations? We've already talked about that a little bit. Yeah. But Judge Glasgow, do you want to add to that?
I guess the only thing I'll add is that for someone who is not steeped in criminal law, it is really helpful for me to see these laid out before you apply the law to the facts of your case. So the places where I feel like our chambers runs into the most trouble in sort of teasing apart an appellant's brief is where everything is all sort of mixed up together in a big washing machine, and I have to dive in there and really try to tease apart what the answer to each of these questions is, because they're kind of scattered all over the place. The best briefs are really good at laying these things out initially, kind of in the same way that we do in our opinions. I know a lot of the judges on Division 2 include legal principles as one of their headings, and then they sort of lay all of that out, and that is a helpful structure if you feel like you're struggling with how to present this.
Yeah, and I would say when you're writing your brief, think about, okay, who are the first eyes that are going to be on the brief? It's going to be a clerk, and then was the judge, well, you know, the judges on the panel, how many are going to be unfamiliar with this particular point of law, or maybe they're not familiar with criminal law because they came from the civil realm. You know, spoon feed it, write it for somebody who is not going to have the background to know what you're talking about. Yeah. Here is the issue. Here is the test you need to use to evaluate my issue. And then here's why I win under the application of that test. So, you know, please write it in a spoon feeding type of way, with the assumption that the person you're writing for is not going to have the background at the front end to understand necessarily everything that you're talking about. And certainly when you're talking about, you know, some of the more complicated tests, you know, double jeopardy or things of that nature, really spoon feed those. And it may seem tedious and it may seem like, I don't know what, but just feel free to really spoon feed it in a very detailed way, as though you're writing for somebody who's not going to know what the test is.
I think that may be the most important thing you could take away from this. I think Judge Cruser has hit on sort of the number one suggestion that we have, and it may not be that you're facing judges who are not necessarily deeply familiar with the law that you're talking about. It's sort of understanding the volume of work that we're up against, and knowing that whenever I'm not feeding my kid or walking the dog or sleeping, I'm reading briefs or working on bench memos that analyze the briefs, or working on draft opinions that analyze the briefs. And so I'm doing a ton of reading, sometimes between 5 and 7 in the morning before my family gets up, or between, you know, 9:30 when they go to bed and 1:30 when I go to bed. And so any little help that you can give me by spoon feeding is much appreciated when we're really tired. And that's not at all to complain. I love this job. It's the best job I've ever had. I love learning all of the new twists and turns in the law and arguing about what they should or shouldn't be. This is a fabulous job, but it is a lot of hard work. And I know Judge Cruser is up in the middle of the night because she sends me emails in the middle of the night. So know that that's what we're up against. And so any little help that you give us is much appreciated.
I would also, what I meant to also add on the, like, for example, in the standard of review, if there's a dispute about the standard of review, it really helps if you do sort of what I talked about a few slides ago. Say, look, I win under both, so I want you to apply de novo standard review. I win under that standard, but if you apply abuse of discretion, I win there too, and here's why. I'm a big fan of alternative, well, it's not an alternative argument, but an even if then argument where, look, I win either way, but here's why I think you should apply this particular standard, or even if there's a dispute about what test to apply. Look, I win under either test. You'll see, the Supreme Court has had maybe a lack of clarity on how to evaluate the constitutional harmless error. And so you have the contribution test and the overwhelming untainted evidence test. So sometimes there's some disagreement about which of those tests are going to apply, as an example. Just say, look, I win under either one, and here's why. So that's just very helpful if you do that. And also if you're anticipating what the state's going to argue about what the test is, if you say why it is that's not going to be persuasive to us.
Good point. Okay. So this slide is really more targeted at times when you, in the rare case where you might be a respondent, but we like to include it because it really does, it really does gain a lot of traction for advocates that repeatedly appear in our court. So it's important to take a look at the arguments that are being made when you are the respondent. And if you think, yeah, I really should concede something, I encourage you to talk to a lot of people to make sure that you are right about the concession and that you have some agreement among practitioners who do the same work that you do. But once you've done that, you shouldn't be shy about conceding something as a respondent on appeal. It is far more helpful to us if that occurs in a brief rather than surprising us with it at oral argument. And it's also important to include a little bit of an analysis because we will take a fresh look at the concession and decide whether we agree with it. And there are times when we have decided we don't. But I don't think I want to belabor that too much because you guys are so rarely respondents. But Anne, was there anything else you wanted to say about that?
Well, I think what I would maybe add in the situation where the state is conceding a point, if you're going to be filing a reply brief, it might be a good idea to let us know whether you agree with the state's concession and maybe support it with your own argument. I didn't realize until I got to this court how much examination there is over state concessions and sort of disagreements about them. I always sort of had this notion when I was an appellate prosecutor that, look, I've conceded. The state is not asking for this whatever anymore. I've conceded. And that the appellate court would just, oh, the state's okay with this, so we'll go with this. It's not how it is. There's a lot of, examination of a state's concession. So if you agree with the concession, it's a good idea to say so in a reply brief. And if you feel like the state could have even been more, given more information about why the concession is appropriate, maybe you can help us by giving us that information or some more law about why the concession is appropriate. So I guess that's what I'd say about that.
Yeah, that's a really good point. Okay.
All right. So this is, sort of just going through a good way to organize your issues. And this is why I like the introduction section of a brief. Full confession, I didn't do those a lot in my briefs. I wish that one of the judges who would come to the many CLEs that I attended, both with OPD and with WAPA, had said, the introduction is really a nifty tool. And so just, hey, here's the rule. Here are the facts that of course in the state in this case, presented, and here's why those facts or this, does not satisfy what they needed to satisfy in order to affirm the case. So You know, I'm having trouble coming up with an example, you know, for a situation like this, but you know, you get the idea that you know, the state was required to prove X, the state produced the following facts, those facts don't prove X. So obviously it's a good idea to do that in your argument section, but I find that it's really, really helpful to do it in the introduction section, which is usually just a page or two. So I know exactly what the fight is about. Judge Glasgow?
Nope, and we'll talk about introductions a little bit later, but I absolutely agree with you about that. On the statement of issues, I think there's a lot out there that you can read about issue statements. So Garner has some issue statement material, and so does Ross Guberman. We gave you the Garner example that we see a lot, and we see a lot from you guys, and I appreciate this style of statement of issues. One thing I asked some of our colleagues what they, if there was anything they wanted us to raise in this CLE, and one thing that one of our colleagues said he particularly likes is the style of briefing where there's a list of assignments of error with a statement of issues interjected in between the assignments of error. So there's a list of assignments of error with, and then the related statement of issues for that list, or that set of assignments of error, and then another set of assignments of error on a particular topic, and then the inserted statement of issue for that set. I'm not sure that that's a universal feeling, but one of our judges on Division 2 said that he really appreciates that style of presentation on the statement of assignments of error and statement of issues.
Yeah, I would say, you know, do whatever you're most comfortable with. I actually tend to find that a little distracting. I actually prefer to have the assignments of error and then the issues pertaining to assignments of error. And I think it can be helpful if you formulated your issue pertaining, if you maybe have a parentheses, this issue pertaining relates to assignments of error 1, 2, 7, and 8. That can be helpful, but when they're up in that section, issues pertaining are up in the assignments of error, I tend to find that distracting myself. But not so much that it, you know, should compel anybody to change their ways. I mean, if it's the way that you're most comfortable writing, then you know, that's just the way it's going to be. But I tend to sort of prefer a more traditional method of just having the assignments and the issues in separate sections. Yeah. So this is, you know, pretty straightforward, and I think that's about all we need to say.
Okay. So once you have your statement of issues crafted, the next step is to start crafting your analysis section. And I feel like this is the place where people can get stuck. I mean, if writers, or well, I guess I should just say, for me, when I was writing appellate briefs, this is the place where I most often got stuck. And if I had writer's block or something, this was the thing that got me the most. And so when I worked at the AG's office, we had Tom Cobb from the University of Washington. He was a legal writing professor at the University of Washington. We had him come in and do some intensive trainings with small groups of attorneys who were most likely to be working on appellate briefs in the office. And we had him help us sort of figure out the best way to talk about how to structure an analysis if somebody got to the point where they needed to start doing that and got stuck. And one of the things that I think that people struggle with a lot is if there is a lot going on in anticipating what the other side's arguments are going to be, and seeing multiple counter arguments coming at you for a particular issue. And so I think the most effective way to deal with that is to put yourself in the judge's shoes again and make sure that you're thinking in terms of spoon feeding to the judge the analysis that you would like them to adopt in their opinion. And understand that we're always going to start with a positive analysis first. So what I mean by that is we're going to set out the relevant law, and then we're going to apply the law to the facts in this particular case. And so we need to do that before we start addressing the arguments that one side or the other is making that sort of attack that analysis. And so you can make the drafting judge's job as easy as possible by following this general guideline for how to deal with those multiple sort of counter arguments that you see coming. So in this sort of dialectical structure of a brief, you're going to give us you're going to tell us why you win first, right? So you can give us your legal premise or the analysis of what the law says. That should include some discussion of how prior courts have applied this particular law, right? Then you give us the facts, and then you tell us how the law applies to the facts of this case. Then you've made your positive case. You've told us how we rule in your favor. Then you can turn to, but below, the state argued, blah, blah, blah. But that was wrong because, and then you can sort of give us the counter to the argument that you're anticipating. And do that for as many of the counter arguments, of the little counter arguments that you see coming. And being able to sort of raise and dismiss after you've given us your positive argument is a really helpful way to structure your analysis so that you're avoiding a little bit of a stream of consciousness all the way through the analysis that doesn't give us that essential roadmap for getting to the place where you want us to be first. Judge Cruser, did you have anything you wanted to add to that?
No, I think you said it great. I think, in fact, in the next slide, we're going to get to what's sort of touched on in the bottom of this slide is, anticipating the arguments of the other side and shooting them down in your opening salvo.
Yeah.
So.
And you'll see that this slide was one that Tom created for us when I worked at the AG's office, and we were most often responding. So it's set up for a respondent, but you guys can use it too in anticipating arguments.
Right. Right. So sort of going to, anticipating the other side is, I think, it's much better for you to have told us in your brief, the state is likely to argue this side of the other thing and likely to rely on this case or that case. And here's why that case is an apposite, doesn't compel the result that they're going to ask you to come to. It's just helpful. I mean, it's, obviously we can read it in a reply brief, but I find it helpful if you've told me in advance what I should expect the state to say, so that I know what you think of it before I get there. I talked with Judge Glasgow. I think every judge and probably every clerk does it a little differently. There are a lot of folks who will read the briefs in reverse order, start with the reply, then go to the respondent, then go to the appellant's opening brief. I don't do that myself. I go in order. Not everybody does, and the clerks will have their own order as well. Some people just feel like the reply brief is where you're going to really get, the meat of what's going on. So it's just a preference with me. I just do it in that order. I start with the appellant's opening brief because that's just the way I think about how I need to see what the issues are and how they're framed before I get to the rest. And so it's helpful for me to see you, anticipating the arguments of the other side. Sometimes it's going to be a little easier. Actually, let's see here. Are we on the next slide? Yeah. So obviously, if the state, there's been a significant issue below that. I guess I could think of one, good example. What maybe you'll see the state make an argument during closing argument where they have misstated the law in a subtle way, or we see this a lot with knowledge. The whole proving actual knowledge versus you will see from time to time some prosecutors who seem to think that demonstrating that somebody should have known something is enough to establish that they did know for purpose of knowledge. And so you'll see that. And so you're saying the state below argued this, here are the facts of the case, and here's why the state's argument A was improper and B was not harmless. So, you can start, when you look at this model here, the state relied below on X, Y, or Z, the reliance mistake, and you can apply that in a variety of situations, whether it's an improper argument or a jury instruction or evidence that maybe sometimes the state relied on evidence that was admitted for impeachment purposes and treated it as though it were substantive, things of that nature. So, this is sort of the framework that we talked about a few slides ago. But so let's see. Becca, or Judge Glasgow, do you have anything you wanted to add to that?
Nope, just don't be afraid to do mini IACs or CREACs in that, within that bigger structure that we gave you from Tom Cobb. So when you're raising and dismissing, you can just do a little mini IRAC and knock out an argument. And so if you're sort of at that architect stage where you're really trying to tease out, gosh, how do I handle this long list of things that I'm anticipating? This is one way to handle that and get moving again.
Yeah, particularly where there's been a misapplication of an evidence rule. Maybe it was 404B or 609 or something of that nature, where the state made an argument about admissibility but your particular facts didn't meet the test for admissibility under that evidence rule. So, say, well, this could be fine for a different case, but not my case, and here's why. So, all right. Let's see, Judge Glasgow, I think this is yours.
Yeah, so these are just some of the pitfalls that we've seen people fall into in crafting their analysis. So the first two bullets kind of go together, and I know that you are short on time, and a lot of you work completely independently without a ton of interaction with colleagues doing the same work. And so I know this can be challenging, but I think that having someone that you kind of partner up with that can give a quick skim to either, the first portion of your brief to sort of tell them what's going on in the case, or that you can call and talk to about the arguments that you're anticipating, and then just talking through what might be the most troublesome problem that you're up against. And then developing the analysis that addresses that argument. I feel like there is often a human instinct to avoid the most difficult part, right? And so sometimes human nature is to try to sidestep or try to avoid. But we don't, while in opinions, we will often pick a particular path in order to sort of thread a needle to address a case. When we are back at the step of developing what we call our pre-hearing memo, which is our bench memo for the court, we tend to address all issues or all possible issues in that memo. So there's a moment in the case when the judge who's assigned to draft the pre-hearing memo for your case has to face the music and deal with every issue. And if there's a really hard issue out there or a really troublesome issue for your position or for your client, and you don't address it head on in the brief, you're not giving us the tools we need to address it in the pre-hearing. And I feel like that's the mistake that I see most often. in an analysis, where somebody just kind of gets that it's a really hard issue and they decide to sidestep it or avoid it and not face it head on. And that leaves me without any input from you about how we should deal with that. Another common issue that we see is sort of stream of consciousness briefings, where we just don't see that IRAC structure. And there's a reason why they beat IRAC into you as a 1L law student. It works, and it's really helpful for us when you follow it. If you're just sort of throwing everything out on the page in this stream of consciousness, that may be your brainstorming that may be your brainstorming about the case, and maybe that's something that you should do at the very beginning of your brief writing. But if you just hand us that work product, that shows us that you haven't put a ton of time and effort into the brief. And so it's make sure you get past that into the actual sort of structuring of an argument, and make sure that you give us that IRAC structure wherever possible. We talked about presenting your positive case first. And then there are two places where I actually see this in briefs. Sometimes I feel like it's the thing that my law clerks and externs failed to do most often coming right out of law school. And that's including in your IRAC structure an application or a discussion of how the prior courts have applied the rule that you've identified. So the classic IRAC structure is your issue, and then you state the rule. Maybe it's a statute, maybe it's a rule coming out of the state Supreme Court. And then what folks sometimes forget to do is to describe for us how either courts of appeals, if it's a Supreme Court case, or later Supreme Court decisions, or if it's a statute, how any courts have actually applied the rule to sets of facts, so that we have something to compare this particular situation to. So people will often forget that step. And so I tell my law clerks, I want you to make it more an IREAC, so IREAC. And I want you to make sure you're including an explanation of how the rule has been applied. The other thing that I feel like I see very frequently is people who think that application means that I just recite the rule and then I just re-recite the facts. I remind you what the facts are, and then I write a conclusion sentence that says, oh, you see, I win. And they forget to explain how the application of the rule works in that particular situation. And when I used to work with other writers at the AG's office as a reviewer or editor of briefs, I found that when I called people when I saw that happening and asked them to tell me, okay, explain to me exactly how this rule applies in this case, they often can do it. They just don't write it down. And if they can't do it, it's because they don't quite understand the rule, or worse, that we have a challenge because we kind of have a losing case. But I think that if you're running into trouble, sort of figuring out how to make sure that your application portion of your IRAC is really effective, it can be helpful to sit down with someone. It doesn't even have to be a lawyer. It can be a reasonably intelligent high school or college student or spouse or whoever, and just talk through how the application of that rule to the facts of this case means that you win, rather than just a simple re-recitation of the facts. So I've talked for a long time. Or Judge Cruser, did you have anything you wanted to add?
Nope.
Okay.
You covered it.
So we are getting to the end of our time today. We planned for this presentation to go over into our next presentation next week. So we will cover the rest of this effective legal writing next week. And then we'll also cover Judge Cruser has some great information and thinking about PRPs, and we'll also cover some appellate procedure issues, some common motions that we see. But one thing we wanted to offer is it would be if you have had questions about either how Division II does things in their clerk's office or any appellate procedure questions that you want to throw out to us, you should feel free to send them to Gideon. You can email him and he will forward them to us, and we will then make sure that we have the answer ready for you next week. And so if there's anything that you've noticed with how Division II processes cases and you want to know more about that, that's your opportunity to submit a question to Gideon and we'll get it figured out for you.